Yes, Ms Monaghan.
Good morning, sir. Good morning. Sir, I speak on behalf of 4 call participants, Mr AK, Paul, Robert James, who I shall refer to as Robert, and Mr AH, all of whom gave evidence before you, sir. They've asked me first, please, to thank you, sir, and the whole of the inquiry team for the way in which this inquiry has been conducted. They've asked me to convey in their own words that they have, during this inquiry, felt listened to, treated with respect, and have felt safe in participating. They've also asked me to say something about the participation and conduct of the Department of Health. The Department of Health and Social Care, of course, are centrally involved in the events being examined in this inquiry and bear responsibility, we say, for much of what occurred, that is, an avoidable catastrophe leading to the deaths of hundreds of people, pain, hurt, life-changing infections of many more, and profound distress and bereavement of yet more. The Department of Health, as you will recall, were allocated 4 hours to make closing oral submissions. At some point beforehand, it appears a short time beforehand, they apparently indicated that they needed only an hour. That is, the Department of Health, they chose to limit their oral submissions before a public hearing at the end of a public inquiry addressed to those infected and affected in the room and listening remotely. They decided to limit their oral submissions to a mere 35 minutes. Indeed, sir, if one takes out your questions, probably more like 30 minutes. My clients consider that derisory, contemptuous and disrespectful. I hope it's clear, I don't think Ms Gray's here, but I do hope it's clear that that's not a criticism of Ms Gray, that's the Department of Health. But perhaps even worse for my clients is the vacuousness of the purported apology. You'll remember, sir, and it's perhaps important to remember, that the Department of Health made an opening statement, and when they made their opening statement in the inquiry hearing room, they were listened to carefully and respectfully by those here, and those included people who had a right to be angry with the Department of Health, and if they'd expressed that anger there and then, they could probably have been forgiven for doing so. But they listened graciously, courteously, and carefully. As you will recall, sir, those in the room expressed their warmth at the involvement of the Department of Health, or at least their counsel, for all to see. You may remember that, sir. In that opening 4.5 years ago, as you picked up on Wednesday, Ms Gray said on behalf of the Department of Health that her clients accepted things went wrong, things happened that should not have happened, and so she said on behalf of her clients, unreservedly, that they were sorry, and that they were sorry that this happened when it should not have happened. In their closing submissions too, they said that things happened that should not have happened, and that they did not depart from their unreserved apology for the fact that that was so. On Wednesday, Ms Gray referred to the sincerity of her apologies and to do what can be done to provide some real and practical assistance. Sincerity of the apologies. When asked by you, sir, what wrong the department had in mind when acknowledging a wrong, Ms Gray was able to say only that the department didn't have a position to offer you. There was no meaningful then, sir, admission of wrongdoing, no meaningful apology. They were empty words, and the Department of Health through Ms Gray is unable to explain why they admitted a wrong when they say they didn't know, unable to identify what wrong that might be. It's difficult to think otherwise than it was an endeavour to close things down. There, we've apologised, that's the end of it. And it was only when you inquired, sir, following Mr Snowdon's raising of the issue, that something apparently had gone wrong and Ms Gray was stumped in answering the question. My clients consider the Department of Health's conduct deeply and grossly offensive. That might be one thing, but it causes them concern too, sir, about what the department might do in response to this inquiry. I'll come back to that at the end, but it is an important matter that these are vacuous apologies, empty admissions, and a contemptuous response to an important public hearing ending this inquiry. Before I come to our substantive submissions, there are two further introductory observations I'd like to make. First of all, again, concerns the Department of Health, but a rather different point. In their submissions, sir, the Department of Health refers to the passage of time and the impact on memory. I don't need to go to that, but for your note or for the note of anybody who might be interested in reading it, that's at paragraph 1.16 of their submissions. They refer in particular to discussion in the case law on the process of setting, resetting and rewriting and the limitations of memory. My clients would like to remind the inquiry, please, sir, and no doubt you will have this well in mind, that for those affected and infected, their experiences are very much seared into their memory in a way that might not be true of others, but it's certainly true of them. And they have continuity of memory because they live with their experiences every day, and the recalling of them is not punctuated by larger lapses in time. So for that reason, sir, it's our submission that considerable weight should be afforded their evidence. Second, Mr Snowdon has expressed disappointment with the way in which the pharmaceutical industry has chosen to respond to this inquiry. As Mr Snowdon said, it's understood that the companies that might be expected to engage are following the inquiry, but have chosen not to actively participate. This has meant that the examination of the pharmaceutical companies that I'm sure everybody would have wanted to see and hear has been lost through no fault of anybody except the pharmaceutical companies. It is them that have decided not to actively engage. And for the avoidance of doubt, sir, for the avoidance of doubt, we do not make any criticism of the inquiry in that respect. As to my clients then, by way of brief introduction, Mr A.K., Paul, Robert and Mr A.H., all of whom, as I've said, the inquiry heard from, are all infected with HCV and HIV. All of them experience testing without consent, secrecy, stigma, harsh disclosure, an absence of support from mainstream services, a lack of empathy from treating clinicians, and misinformation. 3 of my clients, adults at the time of their infections, unlike the 4th, 3 of my clients benefited from support from organisations and clinicians supporting gay men and drug users. I'll touch upon their particular experience as I go along, But with that little introduction, or that short introduction, I want to say something about what binds them together as a group of core participants, because there's nothing obvious about their personal circumstances that would draw them together. But what binds them together are those matters that we identified in opening, that is the stigma associated with HIV and hepatitis C and the impact of that, which I'll come to, and a human rights framework. That is human rights norms that my clients invite you, sir, to have in mind when addressing the issues that you will, in due course, address. And in particular, those human rights norms include the right to life, dignity, bodily autonomy, health, and non-discrimination. Well understood human rights norms observed internationally, regionally, and increasingly domestically. As to the overarching themes that I've just summarised, they are best encapsulated by the words of Robert in his witness statement, his second witness statement. That extract, the important extract to which we refer in our closing submissions, is set out in the written submissions, but mindful that this is a public inquiry and perhaps few people, relatively, will have had the opportunity to read all the submissions, I would like to read that extract because it identifies the approach that my clients take to this inquiry. So can we please have WITN 1004-002. Thank you. And I'd like to look, this is Robert's second witness statement, and he addresses the concerns, the impetus for engaging in this inquiry and identifying the themes that he and the other core participants in my group want addressed. And if I can start by paragraph 3, it is a long extract, but it means I don't have to summarise the points in my submissions. So he says, I've come to see the issues raised by this inquiry as centrally engaging human rights. That's a point adopted by all core participants, as is indeed the whole of this statement. I've approached the making of this statement with that in mind. I believe there's a universal right to be treated with dignity, regardless of an individual's situation. I think the state should only restrict or temporarily suspend a person's rights when that person has interfered with or violated the rights of another. I believe the state has failed me and other haemophiliacs in this infected blood scandal. They failed first by removing the dignity of the groups that became most affected by HIV and viral hepatitis, promoting and reinforcing a stigmatised view of those groups, failing to prevent this stigma from affecting the decision-making of those in positions of knowledge and authority, a matter I'll come back to, failing to acknowledge and implement risk reduction strategies, and ultimately failing to stop a significant number of vulnerable and disabled people in its care from becoming infected with debilitating and frequently fatal infections. From the first appearance of AIDS, there were suggestions it was a judgment from God, and that people with the syndrome deserved to die from it. This perception came on top of state-legitimised stigma against gay people, drug users, sex workers, and migrants. Immediately, it led to a separation between those with HIV that were infected through blood products and others with the condition. This implicitly divided all people with AIDS as either innocent and worthy of care, haemophiliacs, and others as guilty and worthy of blame, gay men, sex workers, intravenous drug users. This division denied those deemed guilty of their human dignity and denied those deemed guilty of their human dignity and ultimately demeaned those innocent. Those of us infected through blood or blood products were routinely exceptionalised, separated from the general service provision for people with HIV, again a matter I'll come back to. I feel strongly that this haemophilia exceptionalism affected the initial risk perception in the early stages of AIDS, the approach to the management of blood products, the provision of clinical care to those affected with AIDS, and the availability of community support services. So stigma and human rights informs my clients' engagement with this inquiry and will inform the submissions I make orally today, sir. That's the statement of Robert, as I've said, but it's a contribution adopted by all of my clients. Moving then, please, to human rights. I will come to some factual matters in due course, but I do want to lay out, if I may, shortly this framework because it is important for my clients. There are three key human rights instruments, we say, that shed light on the treatment and experiences of those infected and affected. The European Convention on Human Rights, the International Covenant on Economic, Social and Cultural Rights, and the UN Convention on the Rights of Persons with Disabilities. Now, at the time of the events we're concerned with, these instruments did not form part of domestic law, but at all times they bound the UK as a matter of international law, and importantly too, they both establish and reflect ordinary human rights norms now expected to be conformed, to be complied with, for states to act conformably with by at least liberal democratic states. So these are human rights norms. So the fact that they're not incorporated or only incorporated in part in respect of some of them doesn't matter to the approach we say you can take to them. And of course, we're not suggesting, for obvious reasons, well, for a number of reasons, in fact, but we're not suggesting that the inquiry make a finding of any legal wrong, and that, therefore, I hope, establishes our position. It creates a framework for understanding.
Well, you're saying that the principles which I should apply are, or I should recognise as applying, are those the state has agreed to internationally, and one would be surprised if it were to accept any different principles in dealing with its own citizens.
Precisely so. That's precisely the point we make. And indeed, that the UK has agreed to adopt those human rights norms, but it's right to say as well that these are broad international covenants. Certainly, the UN covenant is one that's 1966 and widely adopted, or a large number of states are signatories to it and have ratified it. But the point is, as you've properly identified, if I may say so, sir, is that these establish human rights norms, they're international norms, and if there were any doubt about it, we can be satisfied too that the United Kingdom has decided positively that it will conform to those international norms by binding themselves as a matter of international law to comply with them. So that's our introductory observation. And if I can take you, please, to the key extracts that we invite you, sir, to have regard to. First of all, the context, the background, is the Universal Declaration of Human Rights, adopted by the UN General Assembly in 1948. We've got that at RLIT 000 1983. Thank you. And I don't need to read all of this, of course, and you may well be familiar with it, sir, but it's one of the foundational documents of the UN, one of the foundational human rights documents, and importantly, in the preamble, the first page of the preamble, refers to dignity, a point picked up, I think, by Mr. Snowden more generally in his submissions. So whereas recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice and peace in the world, and whereas disregard and contempt for human rights have resulted in barbarous acts which have outraged the conscience of mankind, skipping the next paragraph, the last paragraph in the preamble, whereas the peoples of the United Nations have in the Charter, the UN Charter, reaffirmed their faith in fundamental human rights, in the dignity and worth of the human person, equal rights of men and women, and have determined to promote social progress and better standards of life in larger freedom. And whereas members have pledged themselves to achieve, in cooperation with the United Nations, the promotion of universal respect for and observance of human rights and fundamental freedoms. That's the preamble, and then we get to the substantive articles. Article 1, again, dignity. Foundational to all of these instruments is the concept of dignity and equality, and we see it there at Article 1, born free and equal in dignity and rights. At Article 2, a non-discrimination guarantee, seen again in all the main human rights instruments, protecting or requiring that discrimination is prohibited, that equality is secured, not just in respect of those classes whose status is enumerated, but also other status, which will include those with haemophilia and, importantly too, for the approach my clients are taking, those with Hep C and HIV. Article 3, the right to life. Article 5, torture, inhuman or degrading treatment. Inhuman or degrading treatment. And those are all the extracts. No, in fact, I should take you to one more, which is Article 25. This is picked up in the next instrument that I'm going to take you to. Article 25 is... Lawrence, is that okay? Wonderful, thank you ever so much. Article 25(1), everyone has the right to a standard of living adequate for the health and well-being of himself and of his family. Health is a matter picked up in the next instrument I'd like to take you to, and that's the covenant. So the UN Covenant on Economic, Social and Cultural Rights. I've got it in there shorthand. And again, as I've said, that's one of the older conventions, one of the older treaties. And if I can ask you, please, Lawrence, if you wouldn't mind to turn that up. That's RLIT. Oh, you ahead of me. Thank you. If I can ask you then to please look at that. And in the first instance, again, the preamble, simply to observe in the third substantive paragraph, or let's go to the second just to remind ourselves, recognising that these rights, human rights, derive from the inherent dignity of the human person, and referring in the next paragraph to the Universal Declaration of Human Rights, that which we've just looked at. And then if I can turn, please invite you to turn to Article 2. And we see there, 2.1, each state party to the present covenant undertakes steps individually and through international assistance and cooperation, especially economic and technical, to the maximum of its available resources with a view to achieving progressively the full realisation of the rights recognised in the Covenant by all appropriate means, including by the adoption of legislative measures. And again, so a duty to progressively realise the rights contained in the Covenant, and two, again, a non-discrimination guarantee encapsulating or protecting those whose status is not specifically enumerated, but whose status can be described as another status, as plainly is the case here. And then if I can take you, please, to Article 12. This is a specific provision, a particular provision, targeted provision, addressing health. So Article 12, the states parties to the present covenant recognise the right of everyone to the enjoyment of the highest attainable standard of physical and mental health. The steps to be taken by the states parties to the present covenant to achieve the full realisation of this right shall include those necessary for, and moving straight to small c, the prevention, treatment and control of epidemic, endemic and other diseases. And D, the creation of conditions which would assure to all medical service and medical attention in the event of sickness. So a health guarantee that the UK has promised to progressively realise. In relation to that health guarantee, there's been a general comment by the Committee on Economic, Social and Cultural Rights, and as you'll probably recall, sir, that's the body that reviews monitoring data and state reports, but it also provides general comments which are designed to assist in the interpretation of the treaty provisions. So they're important documents, but they're important too because they're not adding to the Convention's substantive rights. They're simply telling states what they mean and therefore what they have already subscribed to. So if I can take you, please, to the general comment number 14, and I shall just find my reference, RLIT 000 1985. And this is general comment number 14, 2000. But as I've indicated, it's a document to assist in interpretation, not a new set of provisions. Paragraph 1 emphasises the importance of health, as it's the right to health, as it's found in the Covenant. Health is a fundamental human right, indispensable for the exercise of other human rights, and every human being is entitled to the enjoyment of the highest attainable standard of health, conducive to a life living, to living a life in dignity. Again, dignity is the key threshold, the key test for compliance. And at paragraph 3, it acknowledges, we say this is certainly true, the right to, I beg your pardon, sorry Lawrence, I'm ahead of you. The right to health is closely related to and dependent upon the realisation of other human rights, including, as it goes on, human dignity, life, non-discrimination and equality, as well as, the next line, access to information. And then, please, if I can ask you to turn to paragraph 8, the normative content of Article 12. The right to health is not to be understood as a right to be healthy, of course, The right to health contains both freedoms and entitlements. They include the right to control one's health and bodily autonomy, as I shall describe it, and body, and the right to be free from interference, such as the right to be free from torture, non-consensual medical treatment, and experimentation. And the last sentence refers again to equality of opportunity. You'll see at paragraph 10, which I needn't read to you, but starting, or it's in fact the last sentence, although it's rather a long one, HIV and AIDS is referred to in terms noting the particular difficulties, and we would say stigma and lack of support for that growing number of people, populations, experiencing or contracting HIV and AIDS. So those are the main human rights, the general human rights instruments.
Do you want to refer me to the last sentence of paragraph 11?
Yes, thank you. Thank you, sir. So consequently, the right to health must be understood as a right to the enjoyment of a variety of facilities, goods, services, and conditions necessary for the realisation of the highest attainable standards of health. And in fact, it will be as well, or certainly I would invite you to look at the whole of the comment, because you will see over the page, again I won't read it all out, but if you want to take a moment to read it now or later, sir, it's a matter for you, but you'll see that it identifies the constituent elements or the conditions that must be met if the obligation in relation to health is to be met. So availability, accessibility, economic accessibility, information accessibility, one of the things that did not occur here, acceptability and quality. But I commend the whole of it to you because it provides, as I've said, a more detailed structure for examining the extent to which the Article 12 obligation in the Covenant has been complied with. So just in relation to that, and perhaps summarising where we get to, the general comment is a helpful source for summarising that. But we do say that looking through the prism of the rights contained in the human rights instruments, I'll come to the Convention on the Rights of Disabled Persons in a moment, but looking at the events that occurred through the prism of those human rights instruments, we say the inquiry will want to consider the failure to, among other things, the failure to meet the pledge to ensure self-sufficiency in blood products. In relation to HIV and Hep C, core obligations would include facilitating or providing early public health information, particular to people with haemophilia receiving blood products, information about the risks associated with factor VIII and the risks associated with non-A, non-B hepatitis, Hep C, in the 1970s and 1980s, the risks associated with commercial US products, the creation of an authoritative and centralised channel for disseminating public health information, and steps in place to mitigate imminent virological risks, self-sufficiency, alternative treatment, proper licensing, blood security, and importantly, as I'll come back to, appropriate services and dignity. The last instrument I should like to refer you to, sir, is the Convention on the Rights of Persons with Disabilities. That's RLIT, 111, 1986. And I rather suspect you might have read these, sir, but I shall, if you don't mind, I shall touch. I do want to touch upon them because we are.
Well, I have, but as you say, you're here in a public sphere, saying what your clients would want the public to hear.
Thank you. So if I can ask you please to look firstly at the preamble, simply to observe again that this is a convention inspired by the UN's foundational documents, the Charter, we see that referred to at paragraph A, and at paragraph B, the Universal Declaration that I took you to a moment ago. And then if we look please at Article 1, the purpose of the convention is identified. That is to promote, protect, and ensure the full and equal enjoyment of all human rights and fundamental freedoms by all persons with
I think there we are.
I'm sorry.
You were just ahead of the screen.
I'm sorry.
But we're there.
I'm sorry, I'm not quite used to this, and you told me about hurrying, or somebody did, so I'm terribly sorry. Are we there now? Thank you. I'm terribly sorry.
We are. If you want to check, Eva, it's on the screen to your right, of the big screen.
I think it's here, but I was concentrating on my notes and not the screen. But there you are. Apologies.
And you may want to start Article 1 again.
Thank you. So Article 1 identifies the purpose. And the purpose of the convention is to promote, protect and ensure the full and equal enjoyment of all human rights and fundamental freedoms by all persons with disabilities and to promote respect for their inherent dignity. Persons with disabilities are described inclusively and they include persons with long-term physical impairments, which in interaction with various barriers may hinder their full and effective participation in society on an equal basis with others. So I know you'll know, sir, this embraces a social model of disability, so it's concerned less about the focus on a person's impairment and more about the way society, the state, services here respond to those people with impairments. And of course, our clients are disabled for a number of reasons, haemophilia, HIV and Hep C. Article 2, if I can take you please to the third paragraph, discrimination. Again, prohibits or requires states to prohibit or prohibit discrimination and guarantee non-discrimination, noting too that discrimination means any distinction, exclusion or restriction on the basis of disability which has the purpose or effect of impairing or nullifying the recognition, enjoyment or exercise on an equal basis with others of all human rights and fundamental freedoms in all the spheres identified there. And then, if I can ask you please to look at Article 3, the general... I'm going to try and... Forgive me. Article 3, the general principles are identified and emphasising again dignity, respect for inherent dignity, and also now, and importantly, as with general comment number 14, individual autonomy, including the freedom to make one's own choices and independence of persons, and non-discrimination, participation, respect for difference, equality of opportunity, accessibility, equality between men and women, and respect for evolving capacities in relation to children. So discrimination, bodily autonomy, individual autonomy, and non-discrimination. And then at Article 4, reflecting the language used in the Covenant and seen in other international instruments. Article 4, states parties undertake to ensure and promote the full realisation of human rights and fundamental freedoms for all persons with disabilities without discrimination. And for that purpose, states parties are required to adopt appropriate measures designed to secure that. And C, to take into account the protection and promotion of human rights of persons with disabilities in all policies and programmes. D, to refrain from engaging in any act or practice that is inconsistent with the present convention, and to ensure that public authorities and institutions act in conformity with the convention. So a prohibition in engaging in acts and practices inconsistent with the convention, and to take appropriate measures to eliminate discrimination. F, to undertake or promote research and development of universally designed goods and services. G, to undertake or promote research. H, to provide accessible information, something that question of information has emerged many times, and I'll touch upon it in one moment. To promote the training of professionals and staff working with people with disabilities. And in the development 3, subparagraph 3, that's it, in the development, thank you, Lawrence, in the development and implementation of legislation and policies to implement the convention, and in other decision-making processes concerning issues relating to persons with disabilities, states parties shall closely consult with and actively involve persons with disabilities, including children with disabilities, through their representative organisations. What we know here is that there was no sharing of information, no targeted appropriate services, and no participation in decision-making. But I'll come back to that in a moment. And then over the page, in my page it is, Article 5. Again, a non-discrimination guarantee. Needn't take you to that. Article 8. Awareness raising. State parties undertake to adopt immediate, effective and appropriate measures to raise awareness throughout society regarding persons with disabilities, and to foster respect for the rights and dignity of persons with disabilities. Highly relevant to what my clients say and what in due course I will say about the impact of stigma. And then, relatedly at B, combating stereotypes and prejudices. And then 2, so same so it's Article 8, 2. Measures to this end include initiating and maintaining effective public awareness campaigns to nurture receptiveness to the rights of persons with disabilities, and to promote positive perceptions and greater social awareness towards persons with disabilities. Just finally, although I can, finally on this section, still the same convention, but this part, if we look please at Article 15, part of the civil and political rights part of the convention, Article 15, we have there the prohibition on torture or, for our purposes, inhuman and degrading treatment. In particular, no one shall be subjected without his or her free consent to medical or scientific experimentation, highly important, and of course it was important post-war for very obvious reasons, and so we see that issue flagged many times in the various documents. And then paragraph 25, that's the last section I need to take you to. Health. Article 25, health. State parties recognise that persons with disabilities have the right to the enjoyment of the highest attainable standard of health without discrimination on the basis of disabilities. And appropriate measures must be taken to ensure access for persons with disabilities to health services that are gender sensitive, including health-related rehabilitation. And to that end, state parties shall provide persons with disabilities with the same range, quality and standard of free or affordable health care. And then B, provide those health services needed by persons with disabilities, specifically because of their disabilities, including early identification, intervention as appropriate, and services designed to minimise and prevent further disabilities, including among children, and as will become more important to my clients, older persons. And then D, require health professionals to provide care of the same quality to persons with disabilities as to others, free and so on, and inform consent by, among other things, raising awareness of the human rights, dignity, autonomy and needs of persons with disabilities through training and promulgation of ethical standards for public and private health care. So very significant human rights measures, very significant human rights obligations, a focus on autonomy, autonomy, dignity, non-discrimination and positive obligations on the state to ensure that there is a true and realisable right to enjoy health, dignity, equality in services, appropriate services, and non-discrimination. And the very last document I'll take you to, and I know you will be extremely familiar with this, but I will take it just briefly, if I may, again, and that's that one. Thank you. And this is the last document as well. So we have here the European Convention on Human Rights. I know I needn't ask you to study it, but just to flag again, internal number, page 5, please, Lawrence. The preamble, again, the first substantive paragraph, referring again to the Declaration, the Universal Declaration of Human Rights. So again, inspired by those fundamental human rights values that we see immediately post-war. And then at page 6, if we can, we see at Article 1 what the state promises to do. The high contracting parties shall secure to everyone within their jurisdiction the rights and freedoms defined in this convention, the material parts. Article 2, the right to life. I'll come back to that. Article 3, prohibition on inhuman or degrading treatment. And then if I could go to internal number, page 11, please. This is Article 8, sir. I think we're... Yes, Article 8, right to respect for private and family life. Everyone has the right to respect for his private and family life. You'll know, sir, that the concept of private life engages personality, both physical and intellectual or mental, emotional, and so on. It's concerned with personality as well as physical privacy. So important guarantees, and then at Article 14, again, a prohibition on discrimination. As we've said in our written submissions, and I know will be familiar to you, sir, Article 2, although appearing as a negative obligation, imposes two particular obligations, the negative obligation prohibiting a state from depriving a person of life, and a positive duty to ensure that the right to life is protected. But beyond that, there are particular obligations imposed in the case of particular individuals or classes of individuals where there is a known risk to life. So there is a duty arising under Article 2. You'll remember the Osman line of cases. A positive obligation under Article 2 to take protective measures, preventative measures, in the case of an individual or class of individuals where there is a risk to life. There is also a procedural obligation, and this is for historical purposes only now, but there is a procedural obligation, as you know, to undertake a prompt and effective investigation. And I probably needn't say more about that because I think the observations that could be made about that are obvious and have been made by many others. Similar positive obligations arise under Article 3, prohibition on inhuman degrading treatment, as those that arise under Article 2, that is where there is a risk that there will be, or that substantive right will be violated, so there is a risk of inhuman or degrading treatment. And importantly, as I've said about Article 8, it protects one's personality, one's interests as they touch upon oneself. They also, therefore, touch upon bodily integrity, autonomy, and dignity. And Article 14, as you've seen, is the non-discrimination guarantee. So there is a succession of human rights instruments starting immediately post-war, emphasising the need for respect for human dignity in the case of all people, and then specific aspects, life, prohibition on degrading treatment, health, and so on. And those are, as I've indicated, important matters for my clients. With that context, then, I should like to make some observations on the facts, or some submissions on the facts. Firstly, as to knowledge of risk and the response to it, mindful, as I've already indicated, about the positive obligations inherent in the conventions, the duty on the state to do something where risk is identified, the timing of the emergence of risk, or the emergence of knowledge of risk, is important, obviously, because it tells us how things developed, but it's important for my clients too, and no doubt many, many, many others of the core participants, because it helps them understand not only whether the transmission of infected blood could have been prevented at particular times, but whether, in the case of HIV, it could have been eliminated at the very outset, and whether or not, therefore, they may not have contracted Hep C or at least HIV themselves. So timing is important for my clients, and no doubt everybody else participating in this inquiry, for their personal reasons as well as the broader public interest. We had the benefit, and I had the benefit, of hearing Mr. Snowden speak on Tuesday, I think it was, about the emergence of evidence concerning risk of viral transmission associated with blood and blood products. We adopt what Mr. Snowden says, along with our written submissions. We don't that is Mr. Snowden's submissions and our written submissions, in general comprise the submissions that we would wish to make today, and so that those listening understand the position we're adopting, it's no benefit to the inquiry to repeat submissions that have already been made by others, where there's no disagreement, and where we've set them out in their written submissions. So they are extremely important matters, but it isn't necessary for me, sir, to repeat them before you and before those in the hearing room remotely or physically. Having said that, there are a couple of matters I would like to draw your attention to in relation to chronology, but keeping repetition, I hope, to the very bare minimum. What is clear, we say, is that the risk of transmission of viral infection, hepatitis in particular, through the transmission of blood and blood products, was known a very, very long time before the events with which this inquiry is primarily concerned. Post-transfusion hepatitis, as it was then described, was known of by the 1940s, and the relationship between pool size and transmission, increased risk of transmission relative to pool size, was known of well before factor concentrates came to be used in the United Kingdom. As we heard too, by the early 1970s at the latest, evidence had begun to emerge indicating the existence of another hepatitis-causing agent, non-A, non-B, and with the development of tests for hepatitis A and B, it became clear that non-A, non-B, hep C, evidenced, let me just start that sentence again, I've expressed that very badly. What was known with the development of tests for hepatitis A and hepatitis B, and the discovery, therefore, of non-A and non-B hepatitis, what came to be known in consequence is that unknown viruses could be transmitted through blood and blood products. So by the time we're in the 70s, known that viral infections can be transmitted, no pool size is relevant, known that unknown viruses could be transmitted, and soon afterwards, in the case of non-A, non-B, hep C, it was particularly understood that pool size was significant for determining the extent of risk.
Are you submitting to me that non-A, non-B was an unknown virus? The reason I ask is this. It may be thought that much of the material which starts in the 1940s, if not before, identifies that there is something which causes, after transfusion, the effect of hepatitis. And it is identified in the 1940s, if not before, that is most probably a virus. In one sense, it's unknown because no one isolates the virus, no one can test for it, no one can see it under the electron microscope or whatever microscope was used in those days. But there was no doubt that blood had or could have a virus in it, or viruses in it, which would cause effects, amongst which, importantly for this inquiry, was the consequence of hepatitis.
Yes.
But non-A, non-B might be thought, unless there is evidence that it is an actual latecomer, which evidence isn't apparent, I think, in the documents, but I listened to any submission to the contrary, it was always there. It was always part of the viruses that were causing hepatitis. So it wasn't unknown in that sense. What was unknown about it was that it was hadn't yet been, that part of the virus
Yes.
cohort, the virus army that was attacking liver, hadn't yet been identified.
Yes.
So that's what you're submitting to me, is it?
That's what I'm submitting. So when I talk about an unknown virus, I'm talking about a virus that hadn't been identified, and the significance for us of drawing attention to that is it was plain, therefore, by then, that viruses generally were able to move through blood products, and the fact that one couldn't identify it didn't mean that there was an absence of risk. And what was known, therefore, ought to have informed decisions later on, both in respect of Hep C, but also HIV.
In simple terms, you're submitting you don't need to know how something is caused if you know that it is caused by doing something.
Yes.
So, simple example, you press a button over there and a light comes on over there, you press the light switch, you know that if you do that, that happens, you hope, as long as the bulb's working. But you don't know how, don't have to understand electronic theory or electricity or anything, or incandescence in order to work that out.
Yes.
You know it happens. And at a simple level, is disease, you submit like that you know that if you do this, that may happen?
Yes, precisely. And the fact that one can't identify the virus at a particular time doesn't mean that one can't identify the risk factors associated with the transmission of viruses. Large pool plasma, large pools, commercial blood products, and so on. So it's emphasising the importance, we say, of understanding that HIV didn't come out of the blue, in the sense that, of course, it was a different virus, of course it hadn't been identified, but the fact that there was a virus that hadn't been identified wasn't something that ought necessarily have taken everybody by surprise. Viruses were known of. They were transmissible by blood products. The risk factors, large pools, commercial products, were known about and had been known about since the 1970s. So it's really identifying that there's no sudden discovery. HIV is the discovery, what causes viruses to be transmitted, and the risk factors associated with that was something that was known about from the 1940s onwards, increasingly. And blood, of course, the other feature I talked about, size of the pool, but of course paid donors was the other matter. Commercial products was known to be a risk factor in the 1970s. So these risk factors ought to have been well in the minds of those dealing with people who needed the transmission of blood products, like people with haemophilia. Given that it was known that large pool plasma, large pool blood products, commercial products were known to increase risk of transmission, case of hepatitis, the extent of the risk associated with factor 8 ought to have been apparent very early on, particularly commercially produced factor 8. But what we see is that those risks were consistently underplayed, consistently minimised by clinicians, pharmaceutical companies, and others involved in the administering and supply of blood products. There were a number of reasons for that, we say. First of all, there was a general but considerable resistance to anything that might suggest that the distribution of what was seen as a new wonder drug, which should be disrupted. Clinicians using factor 8 expected gratitude from patients and perhaps generosity from pharmaceutical companies, which in turn made vast profits from the production of factor VIII, at times when they knew the risk. So risk must have been obvious by the late 1970s. The risks associated with factor VIII, however, were downplayed for a number of reasons, including an investment among clinicians in what was seen to be a wonder drug and what they could do for their patients, and of course, as we've already heard several times, perhaps informed in part by some clinicians' relationships with the pharmaceutical companies. So a downgrading of risk. And we see that reflected early on. Don't need to take you to the documents. Some of them you may have seen, but I hope I've managed to not repeat. But we see early on correspondence, for example. We'll remember this from Counsel to the Inquiry's presentation. But Dr. Jones, director at the Newcastle Haemophilia Centre and a key player in the UK HCDO, wrote to colleagues in 1974 confidentially, you may recall that, sir, that the link between commercial concentrate and hepatitis had been proved and that it carried the risk of jaundice, but that it was generally agreed that the advantage and indeed the necessity of concentrate outweighed the risk of hepatitis. At around the same time, you may recall, sir, he was writing to colleagues describing the risk of hepatitis contamination as very worrying. So there were frictions between what was said at various times and to whom, but what was certainly the case was that in assessing risk and whether it was worth taking, there was no discussion or involvement of patients. The position we say didn't change, that is minimising risk, when the indicators of what came to be known as HIV/AIDS began to emerge in the very early 1980s, in all probability for the same reason, additional to stigma that I'll come to. Again, as with hepatitis C, I won't track the emergence of the evidence because Mr. Snowden has done that for you on Wednesday. But again, I should like to pluck out a couple of points in particular. First of all, the minute in which Mr. Gunson's report is referred to, the early minutes, July 1982, you'll recall, there's a Department of Health, or DHSS as it was, minute. He was described as consultant advisor. He was also chief medical officer, as I understand it. When he gave evidence, you'll remember, in the
I don't think he was chief medical officer. He was the advisor to the chief medical officer.
I beg your pardon. I had seen two things, and that's why I was advisor to, thank you, advisor to the chief medical officer.
I think the chief medical officer at the time was Sir Henry Illades.
Thank you. So just then to rewind, you'll recall the Department of Health minute, I think, in which his observations were recorded. He was consultant advisor, as you've just reminded me, to the CMO. When giving evidence in the HIV litigation, you may recall, he said he first suspected, and as was presentation given to us about this. He first suspected the link between haemophiliacs and AIDS during 1982, when there were incidences of haemophiliacs contracting immune deficiency. We saw thereafter, in July 1982, the minute I just referred to, when it was reported that he said there was likely to be considerable publicity over the following weeks concerning the safety of American factor VIII. So very early on again, noting concerns about the safety of American factor VIII, given the emerging new virus, HIV, notwithstanding the fact that that would indicate that he was following closely what was happening in the US, we see that he was minimising in due course the extent of the risk. So while he says in his memo, or while it's recorded as him saying in the memo, that the voluntary unpaid donor system adopted by the United Kingdom was safer than the US system, no action was taken in relation to that. We come to see what happened about that. But what we say, sir, is that immediately upon him acknowledging and recognising that the risks associated with factor 8 and the emerging virus, HIV, immediately that warning sign ought to have been met with action, unequivocal warnings to patients and their carers, and a pause in the use of factor 8 at least. As I already indicated, it didn't come out of the blue. The risk of transmission of viruses was known, and the risk factors associated with it, size of the plasma pools, paid donors, were well known. Nothing was done at all. Evidence continued to emerge. I'll come back to what Mr. Gunson says, having identified it at that early stage. Evidence continues to emerge, as you heard from Mr. Snowden, the San Francisco baby case, the 20-year-old man in Cardiff, but still nothing was done promptly. And instead we hear from Professor Bloom giving a reassurance to the Haemophilia Society that it had not been proven that AIDS was transmitted through blood products, and so there was no need for the haemophiliac community to be unduly concerned. So risk was known of. It was a risk potentially of a fatal illness. The risk factors associated with transmission of viruses were long since known, and no action was taken at all. And not only was no action taken, but Professor Bloom, a key player in the UK HCDO, was telling the haemophiliac community that there was nothing to be worried about. Clear warnings then ought to have been acted upon but weren't. We saw then the frightening memo written by Dr. Galbraith on the 9th of May, or dated the 9th of May 1983, in which it's observed that the mortality rate of AIDS exceeds 60% 1 year after diagnosis and is expected to reach 70%. Still, nothing happened. And as I say, rather than sticking to his guns, so to speak, that's not a good pun, but we see Dr. Gunson rowing back on the concerns that he apparently had in summer 1982. So in July 1983, Dr. Gunson, having already flagged the risks, concluded together with Professor Bloom and Dr. Galbraith that a return to cryoprecipitate wasn't recommended, since the perceived level of risk at present does not justify serious consideration of this solution. So again, a playing down of risk, a reduction apparently in the concern expressed by Dr. Gunson earlier on, and matters continued in that vein. So in October 1983, as we heard, at a UK HCDO meeting, Professor Bloom, the dominant voice, as I've said, an important voice, said there was no need for patients to stop using commercial products because at present there was no proof that commercial concentrates were the cause of AIDS. Of course, as you know, sir, proof is not what is required. A risk assessment is what is required, and a risk assessment is required not just as a matter of good clinical practice, and the precautionary principle, but also having regard to the obligations under the human rights instruments that I've just identified for you. Proof is not required. Risk is the focus, and a proper assessment of risk, bearing in mind that the impact of that risk being realised is death, or in all likelihood, death. But no steps were taken. Much was left, as we heard repeatedly, to the judgment of individual doctors. And I can see it's 11:15, and I'm just going to pick that point up. It's a slightly fresh point, so I wonder if this would be a convenient moment to break.
Well, let's pick it up then at 11:45. 11:45.